Hello, welcome to 30 Minutes. I'm Rick Anthony. One of the biggest concerns the parents of a special needs child have, or any family member of a special needs child, is what will happen to the son, daughter, brother, and sister after the caregivers are gone. More specifically, where will the money come from to provide access to the special needs that such a person has? My guest and his wife, almost 30 years ago, began advocating a very special solution to that problem that has provided relief for hundreds of people in the area. My guest today is Jack Rule, an attorney who, as I said, with his wife, has been promoting a terrific solution that he's going to tell us about today. Welcome to 30 Minutes.
Thanks for having me.
I'm delighted to have you. When our mutual friend John Reef told me about you and the work you've been doing, it resonated with me because we have a special needs grandson and have taken steps to provide some financial support for him. When John told me about your situation, I was particularly intrigued because we all know so many other people. If we don't have someone in the family, we know someone who does have someone in the family who is similarly situated and probably will require special care for the rest of their lives. So, John, I guess, as I said, everybody knows somebody. Tell us about your special situation and what impelled you and your wife to take on this cause.
Okay. Well, my wife, Jill, and I...
She's an attorney as well?
She is an attorney. She actually is... we met in law school, and we're working for two different offices when our second child was born, David, and it was clear he had some significant disabilities. Jill kind of suspended her practice to devote more time to him, and it was a good decision. And so she provided extra care for him at home, which allowed him to get a good education, and now has kind of rejoined the practice and actually works in our office. I had been doing work even before David was born for some nonprofit intellectual disability providers in Southeast PA, so it was somewhat of a coincidence. And it even started talking to their parent groups and advocating about specifically special needs trusts. Then when David came along, it was something that we then had to know both from a professional standpoint and a personal standpoint. So I think we could both commiserate with and empathize with the families that go through this decision making. Special needs trusts are been around in the law in Pennsylvania for goes back to about the late 70s, and there are a couple of different types of trusts, and we can talk about today.
Has the title been the same since the beginning? Special
To a
needs
certain
trust?
extent, yes. Special needs trust.
It's a form of an advisory trust?
Well, it is a type of a support trust, a trust that supports an individual, and we can contrast that with a general support trust. That's a trust that basically is set up to say, you shall provide assets for this person's benefit or income. The main difference between a special needs trust, and now we're talking primarily about a trust that's holding family money, is that the trustee is given a high degree of discretion and basically given the power to not spend and withhold resources if it would have the effect of being a resource that would disqualify the beneficiary from means-tested governmental benefits. That's the challenge that you have for a person with a disability. Many programs exist that can be of benefit to a person with a disability that are means-tested. If they're deemed to have resources, either income resources or principal asset resources, they will not qualify. Those assets either have to be eliminated or spent down for them to be able to qualify. And some of them are very significant. Medicaid for their medical coverage.
Yes.
A lot of programs involving like respite care or even residential care, such as a group home or an independent living facility arrangement, are tied to Medicaid funding and they're means tested. So the existence of resources becomes a problem. Up until the late 70s, most of the planning for people with disabilities was really non-planning. Assets would be set aside with other family members in non-formal, moral trust arrangements. In the late 70s, the Pennsylvania Supreme Court approved the concept of parents setting up these discretionary trusts, and for the first time, parents could set aside true trusts which would not be considered resources. The next development in the term, in the concept of special needs trust occurred in 1993 when the Social Security Act was amended, and Social Security allowed two forms of trusts that could hold actually the assets owned by a person with a disability, and if those were placed in these types of trusts, they would no longer be considered resources. Two types of what we call first-party special needs trusts, because they don't hold third-party or family money. One is just a standalone trust for the individual to hold their assets. Another one is called a pooled trust. That's a trust that has shares created in it, and those have to be maintained by nonprofit 501c3 type organizations, and they can receive shares of multiple individuals within this pooled trust, and it's managed by the nonprofit agency. So that's kind of the universe of pooled trusts that we have today to work with families.
But let's go back to the beginning. What's the definition of a disability for purposes of any benefits from federal or state government?
You're primarily for certainly the first party special needs trusts, and for most of the means tested benefits, you have to meet the Social Security definition of disability. That looks to your inability to hold what they call any meaningful gainful employment by reason of your disability. And they come at that from a couple of different vantage points. Certain conditions are almost categorical disability, blindness. My son's disability, his primary diagnosis is cerebral palsy. That is almost a categorical disability. Others have to be, it's a functional test that Social Security would apply. They have an income test as well, and it's very low. For 2014, I was just looking at the numbers yesterday. If you can earn from employment just slightly over $1,000, I think it's like $1,079 a month, you're not considered disabled for Social Security. Yeah. So
but it's earned.
Earned. That's earned from employment. That's right. However, if you were getting income resources, they would certainly look at that as well. And principal resources can be as low as $2,400. For a lot of what they call the waiver programs, which they're tied to a lot of our programs, it's $8,000.
You've already made the case. It's complicated. It does need some deciphering and some expertise.
But very little resources
in trying to find your way through it.
That's right.
Okay. The second question is: Can only parents or other family members contribute to a special needs trust?
It depends on the type of trust you're talking
Why
about.
did I know you were going to say that?
Okay, all right, well, because that's what lawyers do. In the third-party special needs trust, anybody can set those up. That's family money, it's third-party money. Parents could set up their own trust, and other family members could contribute into that to make it easy rather than have multiple trusts. When you're talking about a first-party special needs trust, that arises specifically out of the Social Security statute. That statute says that those trusts can only be established by a parent, a grandparent, an order of court, or a guardian. And that includes for either the standalone trust or the pooled trust. One other caveat: a pooled trust does also appear under the law to be able to be authorized directly by the disabled individual himself or herself. So there is a wrinkle there that some people will debate, but my reading of the law is that a person can create a pooled trust share on their own. There is a bill currently in Congress to expand the ability to create your own first-party special needs standalone trust to the disabled individual. I'm not sure where that is in Congress.
Jack, regardless of the type or the label, is the principal advantage of setting up a special needs trust to preserve the eligibility of the individual?
Absolutely.
For statutory benefits of one kind or another?
Yes.
That's
Certainly the
principal
first-party ones, yes. Certainly for the first-party trust. And third-party, yes, as well, in the sense that you don't want to jeopardize those benefits.
Yes.
And I think for the planning I do with families and for our own family, there's also the added aspect of if you have the means to fund it with some significant dollars, you have funded a trust that also can provide benefits where the government can't, or if in fact the government isn't providing benefits. I mean, there's no guarantee looking into the future of
Yeah.
exactly what the funding
Sure.
is going to be. Currently in Pennsylvania, there are tens of thousands of people who are eligible for different types of disability services who are on waiting lists. And a lot of those individuals are living at home with parents
Yes.
who are aging out in place, like my wife and myself.
Yeah.
And at the time when they can no longer care for their individual, their family special needs trust may play an important role in providing coverage and care while that public system is being navigated.
How is the money in the trust managed? How is it invested? What are the tax effects of putting money in initially?
Right.
And then, of course, earning money over some period of years. And I've got 14 other questions to ask. Go ahead.
Well, the family trust can either be set up during the lifetime or can arise out of a parent's will.
So
And
insurance proceeds could go
insurance
into
proceeds could be tied to it, absolutely. It's one of the major funding sources. There is no real tax impact in terms of setting up and funding the trust. It's a gift at that point into the trust. A first-party special needs trust is considered under the Internal Revenue Code as a grantor trust, and that's important because it means that there's no trust tax return filed for it. It just, that income just, if there would be income, automatically comes out to the beneficiary, whether they've actually received it or not. The family trust, the third-party trust, is not a grantor trust. I believe it can be considered what's known as a qualified disability trust. Now we're getting into some very technical language. It does have some income tax
I'm
consequences.
impressed you're doing this without a single note.
You know, I've been living it for 30 years. It's a type of trust that that has some slight income tax advantages over if it wasn't considered a disability trust. And that just means that you don't get into the higher income tax brackets at quite as early as you would if it wasn't.
The money that comes out of the trust as income to a disabled an eligible disabled person, that's not taxable, or is it taxable to the individual?
It would
of
be,
course, in a lower income tax bracket.
yeah, if you distributed income out of a third-party special needs trust, it would be considered a pass-through of income in that year, and it would be taxable to the individual that year. It's when it's accumulated in the third-party trust is where you get into an income tax situation, and that's where if you can qualify it as a qualified disability trust, you don't pay as high high rate of tax.
Does the income from the trust go directly to the beneficiary, or does it go to a caregiver or some institution's facility who is taking care of the individual?
It almost always goes indirectly to someone, not
really?
directly to the individual with and that's usually because many of the beneficiaries are on SSI, Supplemental Security Income, and direct payments to them would be considered an income resource and could lower the amount of their SSI that month. And generally, the better approach, what I advise trustees to do is to, wherever possible, make payments for the benefit of the individual, either out of a first-party or third-party special needs trust. If they have a specific, say they're getting additional therapies, pay the therapy company, just have the therapy bill submitted to the trust. Okay.
So there has to be an administrative intermediary?
Well, the trustee handles that.
Okay.
Yeah, the trustee would handle that. And in the case of a pooled trust, it would go through the nonprofit organization that's serving as the trustee, or sometimes they will outsource that to a company.
What happens in the event that the disabled person outlives the trust, and so there is money left in the trust?
Right. That's a major distinction between, again, the third party or family special needs trust and a first party special needs trust. The family special needs trust, one that I would create, or my wife and I would create for our son, we would and should have a gift over provision or an alternative provision at David's death or at the death of the beneficiary. It could go to other family members. It could go anywhere we wanted to a charity.
Go to other family members
Others, let's say
who may
David's
or may
siblings,
not,
for example, you know,
who may or
or
may not be disabled.
right,
Anybody.
exactly, right.
Okay.
There's no requirement in a third-party trust that ultimately the share remaining or any funds remaining at the disabled individual's death has
Okay.
to stay there. It can come out to family members or wherever the people creating the trust want it to
Right.
go. With a first-party special needs trust, now let's look at the standalone ones first. If we create a standalone trust to hold just the money for the disabled individual. The quid pro quo that the government took by allowing those trusts to be created and not be considered a resource during the lifetime of the individual is that upon the death of the person, if there is money remaining, funds remaining, it has to go back to the government to the extent of the Medicaid funds that person received during their lifetime, up to wiping it all out. A pooled trust, there was a debate about what happens to it. Basically, that debate in Pennsylvania has been satisfied in basically that the funds either go back to the government, depending on the terms of the trust, up to the amount of Medicaid, or they remain with the trust. Bottom line is, on a pooled trust, the money never comes back out to the family, ever, under any circumstances. It's either going to go to the government or remain with the pooled trust, the nonprofit, for other benefits and other persons they could benefit with it. There is a possibility in a first-party standalone trust that funds could come back out to the person's family. And we always do put heirs in there, but that would only be if there was enough money in that trust that it would fully repay the Medicaid and still be money left over. In that case, it would come out to that individual's statutory heirs.
Doesn't that create a situation where the person creating the trust, the parent, the grandparent, and so on, compels them to manage the amount of money that is put in the trust over a period of time so to avoid the government's having a windfall?
Well, yeah, to a certain extent it does. And really it's a choice of what type of trust to use.
Yes.
In other words, our advice to families is that you don't want to put third-party or family money into a first-party trust, ideally, because of that potential loss.
Right.
It only can be the individual's own money. And there are ways to arrange the family affairs that you can try to keep that amount low. One of the major uses of a first-party special needs trust is to make sure that person's eligibility continues. You've already alluded to that. So you would have a choice, let's say, if you were managing your son or daughter's resources on a monthly basis and they were earning some income from employment, they were getting the monthly disability check, either SSI or SSDI, and now it's building up in the bank and it's going to go over $8,000. You can move it out to that first party special needs trust and continue to fund it, but knowing that whatever that amount grew to be would never come back out to the family, likely would go back to the government. Well, another alternative is to create a third party special needs trust, which does not go back to the government. And Social Security assumes if you're caring for your son or daughter at home that you charge a rent. That's what the SSI they get is supposed to go for. A lot of parents don't do that, and they just let the money build up.
Yeah.
The better approach is to actually charge rent, charge it at the highest level you think appropriate, even if you don't really perhaps want to take all of it.
Yes.
But you put it in your bank account, you recognize income on it if you have to. And if you feel like you've gotten more than you want from that income for the year, you move that excess into your third-party special needs trust, which still would stand for your son or daughter just to the same extent as theirs would, but it doesn't go back to repaying the government.
You're exhibiting a level of sophistication that most people don't have, therefore the need for people like you. But my bet is that most people who have a need for what you're talking about, assuming they have the means to do it, have no idea, no clue. What kind of services are available to them to at least make them aware that there are such instruments, that they do exist, that they can be shaped to suit their needs. And from what you said, you don't just create it and forget about it. You continue to monitor it, manage that resource.
Yeah. Well, certainly the family trusts, they don't have to be cast in stone. That's one good thing, in the sense that they can arise out of a will, so that they can be tailored and amended as circumstances arise.
But who's going to tell the parent, the grandparent, the family member that
Well,
you should at least look in, these,
Yeah.
this is what's
Yeah.
available, this is what you should look into, this is the help you need to make the right choice. Who brings that to the attention? Are there services that the government provides?
There's some websites that the parents
Okay.
can look at.
What's your
One-
website, for example?
Well, our website is just the name of our law firm, MillerTuretsky.com. We do have materials there on the website that can help you. I'm also aware of a nonprofit foundation that I was part of setting up. It's called the Special Needs Education and Resources Foundation. Long name, Special Needs Education and Resources Foundation. It goes by the acronym. We always call it SNERF, S-N-E-R-F. Makes it people to remember it. That has a very good website that has a lot of materials on it.
Right.
The parents can also go to a website maintained by the Academy of Special Needs Planners.
Huh.
They have a side both for attorneys, like that I would go into, but they also have a site that's available to the general public, and it has ongoing news and updates and general information about special needs, particularly special needs trusts, Academy of Special Needs Planners.
Is this beyond most community foundations, or can they set up these trusts?
A community foundation could, any 501c3 could set up a pooled trust for their benefit. I was involved with another company that did work for disability providers about 12 years ago, and we set up a prototype trust that 14 providers around the state have adopted. And so I'm involved in the pooled trust end of it almost on a weekly basis and helping these 14 nonprofits administer their trusts, and this other company, along with a bank, a custodian bank, does all the background, back office work for the nonprofits. They just have to make the kind of the heart decisions on who needs what and what distribution should be made, but all the financial management is done behind the scenes.
What happens in the event that the beneficiary improves? Asperger, for example, or somewhere on the autism spectrum.
Right.
So they're able to function, they're able to get a job. They're very fortunate for whatever reason, and they exceed the threshold. What happens then to the
Well-
money in the trust? They become ineligible, I assume, or they're disqualified, whatever the appropriate
Right.
word is.
You have to look at this from a couple of different perspectives. First, from the third-party special needs trust perspective, those funds still remain available to the individual.
But not dispersed.
They could be. In other words, if it's the family money that's in the family trust, in other words, that's a discretionary trust.
I'm saying as if I
yeah.
understand what you're saying. and
Well,
following
and the
this.
trustee has the discretion to withhold or disperse. So if you have a beneficiary who no longer is getting means-tested benefits but still has needs, the trustee is fully free to continue to give funds for that benefit. Now, from the first-party special needs trust side, that may be holding the funds of the person with a disability himself or herself, that would be more restricted, because those trusts are generally interpreted as having the power to make distribution only for things related to the disability or that are ameliorative of the disabling condition.
Right.
So that could be a little more restrictive, and that's why we tend to say, in terms of money that's allocable within the family to a third party versus a first party, you want to allocate as much money as possible to the third party trust. You can also design family trusts to hold the family money to be what we call it's not a fancy legal term, but we call it a trigger trust in our office. It's a trust that gives the trustee the power to, generally it starts off as a general support trust, assuming that the person may not have means-tested benefits ultimately. The person with Asperger's, for example, who learns to accommodate to their disability and does function without being considered disabled for Social Security purposes. But by the same token, if the person does not get to that level and would be considered disabled and in need of means-tested benefits, the trustee has the ability to kind of flip the switch, flip the trigger,
Right.
and cause the trust to be guided by a whole separate set of provisions in the document that meet all the requirements for a special needs trust and wouldn't be a resource that would disqualify the person. So there are different approaches. But yes, you know, if there was a lot of money or money held in a special needs trust, and you know, first party special needs
Right.
trust, and it was clear that this person had overcome their disability and was not going to need this in the future. What
Right.
would likely have to happen in that case, you'd have to petition for that trust to be terminated. You would have to repay Medicaid, and if there was money left over, it could come out probably for the
It's not
person's
possible
benefit.
to reassign the benefit, to name a new beneficiary?
Not in a first party
In
special
the
needs
family?
trust, no. Not in the first
No?
party trust. In
Okay.
a third party, you can do whatever you want because it's just,
Okay.
you're freely amendable and changeable.
What kind of assets can be placed in a trust other than money, cash, real
Well,
estate?
cash and investments. Real
equities
estate
and
is
so on?
real estate is certainly permissible. I think real estate works the best in a third party special needs trust where you can also put additional money to maintain and keep it up. But it is not you know, impermissible for real estate to be in a first party special needs trust under certain circumstances. Let me give you a quick example from a real case study.
Please.
That we did. We had an individual who was referred to us by his brother. His brother and his sister-in-law were very proactive in seeing to his care. They knew that, you know, he was living at home with this individual's mother, their mother. Mom was in her 90s at that point. Dad had already died, and their disabled brother was living at home, living together in a townhouse. Mom was not doing well. She was dying. No provisions had been set up yet. They were having some temporary nurses come in to look in on him. So we looked into the situation. She wanted to leave him some significant assets. So we created a special needs trust to hold the assets she wanted to leave for her son in a special needs trust, third party. We also discovered that the son had, by just savings, by gifts he received, some light employment, he had $70,000 sitting in the bank in his own name, which would have to be spent down in order for him to
yes.
get off the waiting list for services
Yes.
and to be considered into the system. That's not a tremendous amount of money to spend down. It's not insignificant, but it would delay the county and the authorities
Yes.
taking it seriously. So mom, being still the parent, was able to under the law to create a first party standalone special needs trust for her son. She did so along with her, you know, her plan. She actually died 3 weeks after the documents were put together, but she was perfectly with it at the time and luckily awake and aware. We moved the $70,000 into the special needs trust for the son, and he was able to be put to the top of the emergency waiting list, and a government-supported program put in place for him about 4.5 months later. The townhouse was moved into mom's third-party special needs trust. Through the government program, caregivers were found from the community to come in and actually serve him in his own house where he was familiar with, and he goes on from there. If that hadn't been done, he wouldn't have qualified for anything.
Yeah.
It would have to been done by the brother and sister-in-law with putting together a patchwork of caregivers. I'm sure they would have done it, but the government programs, the government-supported programs, are the ones that are really the experts right now in the field, and I think there will be more providers coming along that will be funded by private money, but for the type of care that he needed, that was, setting it up that way allowed that to be
Yes.
reasonably seamless. It's never perfect, but it would have been years of delay without it.
This has been really informative, instructive. I must admit you've made my hair hurt. I'm trying to follow you through this maze. Let's conclude with a bit of advice you would give to anyone who is similarly situated.
Right.
What should their means level be for them to even seriously consider what you're talking about? How much money should they be able to put in, or value of the assets to put in a trust without sacrificing too much?
Right. Well, I mean, I think that it goes in really at the death of both parents, so it shouldn't require anything that would hamper their lifestyle now. I think that they should look at resources their son or daughter may be getting right now to see if there's a way that those resources could be set
You and your wife
aside.
started your trust
We did. but
Almost 30 years ago.
That's right, but it's going to be funded out of our estate. It's going to be funded out of
I
some
see.
life insurance. We do have a standalone third-party special needs trust that if there's some, we believe is extra household contribution that David has made, we put that in there for him, but that's in lieu of a first-party trust for him, and he has his own first-party trust as well, in case something untoward happens and there's some funds that need to be put aside quickly to maintain his eligibility. But my advice to parents are to, very often when you're involved in the planning process, and I felt it in our own life, that you're always looking for kind of the perfect plan.
Yes.
There's no such thing, really. And it gets in the way. It's like the deer in the headlights. My advice is to make a plan, and once you have a plan in place, it kind of gels your whole thought process. It may be something that you have to pick up and review every 2 or 3 years, and you may have to make adjustments to it. But the first step is just to get something down, something in place, and then you continue to monitor it from there.
Good counsel, Counselor. Thank you very much for being here. It's been valuable information. I hope you learned something. Until next time, this is 30 Minutes. I am Rick Anthony. Take very, very good care of yourselves.